What's up, everyone out there in YouTube world, Facebook world, social media, the world, wherever you're watching the episode from here today. Welcome to another episode of Musings with MGL. I'm your host, as always, MGL, coming at you once again from the lovely Sunshine State of Florida in the home office today. Because let's face it, when you can work from home and have this be your office, why would you physically go to the office? So today I'm going to do a video on a highly controversial or talked about or confusing concept out there, and that's the concept of a straw purchase as it relates to firearms. But before we get into it, as always, like, comment, share, subscribe. I'm getting close to 1,000 subscribers, which would be a pretty cool goal. So if you can just keep sharing this or hit the subscribe button and the bell down below to find out when I post new content, I would greatly appreciate it. So what is a straw purchase? Well, I'm going to start with the general concept definition. And the reason why I say that is there is no law called straw purchase. You can't go to a federal statute and look up the phrase straw purchase and find it in any federal statute. You won't even find it on, I don't believe, the ATF website where it tells you what a straw purchase is. Straw purchase is the slang term that people use for people who use other people to buy their firearms. Okay, so I can give you the slang definition of it, but I can't read to you a statute and tell you what straw purchase is, because it's not a crime. Straw purchase, it's not, you don't indict somebody and put on their indictment for straw purchase. Okay, straw purchase is the slang term for what we'll get into shortly is the actual crime. Okay, so straw purchase in a nutshell basically means when one person has another person go buy a firearm on their behalf. In other words, I, John Smith, want to buy a firearm, but I don't want to go into the shop for whatever reason. Maybe I'm a prohibited person, like a convicted felon, or I have an injunction against me and therefore I can't pass a background check, or maybe I just don't want to buy it because I don't want my name to be on a government document that they're going to keep up in the ATF, or maybe I'm just lazy and don't feel like going down to the shop, so I want to have my Uncle Joe buy it for me and just give it to me later. But it's essentially when one person has another person go buy the firearm on their behalf, meaning I am the actual purchaser and possessor and the person who's going to obtain the license or the firearm, but I'm not the one going into the store and filling out the 4473 background check form. I'm having the other person go do it, and that person is going to say that they're the ones who are actually buying the gun, even though we both know it's not for them, it's for me. Okay, so in a nutshell, that's basically a straw purchase. It's applied to basically everything. You can do a straw purchase for buying a car, buying stocks, whatever. It's not strictly limited to firearms. But when it comes to firearms, the concept is one person has another person go buy them a firearm on their behalf. Most of the time, it's a prohibited person is usually where most of those come in, meaning they can't pass a background check, so they have somebody else go do it. But there's all kinds of other reasons why you might do it. Sometimes you don't even have to be the one who hands over the cash. We'll get into it in a little bit. It gets confusing. But again, the simple concept is one person has another person go buy them a firearm. So that's what's considered to be a straw purchase. Straw purchases are illegal, but again, you're not charged with straw purchase. What you are charged with is lying on the 4473. Okay, so we all know, and if you don't know, I'll walk through real quick what a 4473 is. I have one pulled up here on the screen. That's the background check. Okay, anytime you go to a licensed firearm dealer and you want to purchase a firearm, you have to fill out this form. It's called a 4473, which is a background check form, is basically the slang. So when you go buy a gun, you have to fill out this form. Obviously, you put in your name, your address, date of birth, identifying factors. So you put in the specific information, and then there's a bunch of questions that they ask you on the form, and you have to put in the correct information, and you have to answer the questions truthfully. If you don't do that, if you lie on this form, that is the federal crime, and we'll get into that in a minute of what that actual crime is. But the crime that we're talking about here is providing false information on this background check form. Okay, so the question that we're always dealing with here is basically the first question that comes up. I guess is the second question. The first one is Well, it's answer the following questions. So the first question is, yes, number 21A, as you see on here. Are you the actual transferee slash buyer of the firearm listed on this form in any continuation sheets? And then it says in bold right there, warning, you are not the actual transferee slash buyer if you are acquiring the firearm on behalf of another person. If you are not the actual transferee slash buyer, the licensee cannot transfer the firearm. Exception, if you are only picking up a repaired firearm for another person, you are not required to answer 21A and may proceed to question 21B. Now, so that's it in a nutshell. The very first question says, are you the person who's going to buy this firearm? Are you the actual transferee slash buyer of the firearm? So if I, once again, tell somebody else, go buy the firearm for me, and that person goes into the shop and they mark yes, that's a lie, because they're not the actual transferee slash buyer. I'm the actual transferee slash buyer. They're just the one filling out the form. So when they mark yes to 21A, they are committing the federal crime of providing false information on this background check form, and that in and of itself is a crime. Okay? Note, it doesn't say that it has to be a prohibited person, that I have to be a prohibited person. It doesn't say even that money has to change hands. All it says is if I am buying this gun for somebody else, not as a gift, we'll get into that in a little bit, but if somebody else has asked me or gotten me, or I am buying a gun knowing that it's not for me, it is actually for that person, you have lied on this form. And when you go up here to the top of it, it lays out what the penalty is. The information will be used to determine whether you are prohibited by federal or state law from receiving a firearm. Certain violations of the Gun Control Act are punishable by up to 10 years imprisonment and or up to a $250,000 fine. So, if you lie on this form, that's what you're looking at. 10 years in prison or $250,000 fine. So, that is the actual crime. So, the actual crime is this one, okay? It's under, right here, 18 U.S.C. Section 922 sub A sub 6. Now, what I have pulled up here are the jury instructions. You learn when you're a lawyer that it's actually easier to go to the jury instructions than it is to go read the statute, because the statute usually puts a whole bunch of other stuff in there that isn't necessarily important to what you need to know. But the jury instructions will tell you what it is the state has to prove in order to show that you are or that you have committed the crime. So a little trick, if you want to know if what you're doing is illegal, you can go to the statutes, but if there's a way to find what the actual jury instructions say, sometimes it lays it out better. So when you look at this, here's what the jury instructions say. Defendant is charged with making false statements in connection with trying to buy a firearm / ammunition. Specifically, and then you put insert alleged false statement, it is against federal law to knowingly make a false statement in connection with trying to buy a firearm / information. For you to find the defendant guilty of this crime, you must be convinced that the government has proven each of these things beyond a reasonable doubt. First, the defendant knowingly made a false statement as charged in the indictment. Second, that at the time he or she, they're going to have to update these because I think some people might get mad with the he or she designation there. Maybe you should put they, them, I don't know. Well, that's a subject for a different video. So that at the time he or she made the statement, defendant was trying to buy a firearm / ammunition from a licensed dealer, importer, manufacturer, etc. And third, that the statement was intended to or likely to deceive the licensed dealer, importer, licensed manufacturer, collector about a fact material to the lawfulness of the sale. The defendant does not have to prove, or the government does not have to prove that the defendant knew that he or she was violating the law. A statement is false if it is untrue when made. A false statement is made knowingly if the person making it knows that it is false or demonstrates a reckless disregard for the truth with a conscious purpose to avoid learning the truth. Intent or knowledge may not ordinarily be proven directly because there is no way of directly scrutinizing the workings of the human mind. In determining what defendant knew or intended at a particular time, you may consider any statement made or acts done or omitted by the defendant and all other facts and circumstances received. You may infer, but you certainly are not required to infer that a person intends the natural and probable consequences of acts knowingly done or knowingly omitted. It's entirely up to you to decide what facts are proven by the evidence during this trial. So here's what you get charged with, okay? You don't get charged, again, you see up here, it doesn't say straw purchase. In order to prove a straw purchase. No, it's false statement in connection with trying to buy a firearm. This is for everything on that form. If you lie on that form and say that you are not a convicted felon when in fact you are, this is what you get charged with. If you lie on that form and say you do not use illegal narcotics and it turns out that you do, this is what you get charged with. So there is no such statute, again, as straw purchases. You get charged with 18 U.S.C. 922 sub A6, which is making false statements in connection with acquisition of a firearm. So if you're the person that goes in and you mark that box and you lie on that box, you get charged with this statute. If you're the person who's out in the parking lot waiting for me to bring the gun, you will get charged with aiding and abetting a false statement in connection with acquisition of a firearm. So everything is basically related to this charge. So you can't lie on the form. That's essentially what a straw purchase says, is for that question, the very first one that's on there, the 21A, you have to be the person who actually is the buyer of the firearm. Now, a lot of people think, and this is where the confusion comes in, is that it's only if it's a prohibited person. So unless a guy in the parking lot is a felon, it doesn't matter. I can go in there and buy a gun. If I want to buy it for my uncle, let's say my uncle's a legitimate person, he's not a prohibited person, he just wants me to go to buy the gun for him because he doesn't want my name to appear on something, or he just lives in Miami, he doesn't want to drive up here, so I go buy it on his behalf knowing that it's going to be his, but as long as he's not prohibited, it's perfectly legal. Incorrect, okay? There's a Supreme Court case right on point. I pulled it up here. It's called Abramski versus United States. It's right here. It's from 2013. Petitioner Bruce Abramski offered to purchase a handgun for his uncle. The form that federal regulations required Abramski to fill out, Form 4473, asked whether he was the actual transferee / buyer of the gun, and clearly warned that a straw purchaser, again, the Supreme Court uses that phrase because everybody does, but it's not an actual statutory phrase. Namely, someone buying a gun on behalf of another was not the actual buyer. Abramski falsely answered that he was the actual buyer. Abramski was convicted for knowingly making false statements with respect to any fact material to the lawfulness of the sale of a gun. There's that statute, 18 U.S.C. 922A6. And for making a false statement with respect to the information required to be kept in the gun dealer's records. So there's another statute that talks about how firearm dealerships are required to keep accurate records. When you lie on the form, what you're essentially doing is preventing them from keeping accurate records, so that's a whole nother statute as well. Abramski contends that federal gun laws are entirely unconcerned with straw arrangements. So long as a person at the counter is eligible to own a gun, the sale to him is legal under the statute. To be sure, federal law regulates licensed dealers' transactions with persons or transferees without specifying whether that language refers to the straw buyer or the actual purchaser. But when read in light of the statute's context, structure, and purpose, it is clear this language refers to the true buyer rather than the straw. Federal gun law establishes an elaborate system of in-person identification and background checks to ensure that guns are kept out of the hands of felons and other prohibited persons. It also imposes record-keeping requirements to assist law enforcement authorities in investigating serious crimes through the tracing of guns to their buyers. These provisions would mean little if a would-be gun buyer could evade them all simply by enlisting the aid of an intermediary to execute the paperwork on his behalf. The statute's language is thus best read in context to refer to the actual rather than nominal buyer. This conclusion is reinforced by the court's standard practice of focusing on practical realities rather than legal formalities. Abramski argues more narrowly that his false response was not material because his uncle could have legally bought a gun for himself. But Abramski's false statement prevented the dealer from insisting that the true buyer, Alvarez, which is his uncle, appear in person, provide identifying information, show a photo ID, and submit to a background check. Nothing in the statute suggests that these legal duties may be wiped away merely because the actual buyer turns out to be legally eligible to own a gun. Because the dealer could not have lawfully sold the gun had it known that Abramski was not the true buyer, the misstatement was material to the lawfulness of the sale. Abramski's misrepresentation about the identity of the actual buyer concerned information required by Chapter 44 of Title 18, blah, 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 to be kept in the dealer's records. Chapter 44 contains a provision requiring a dealer to maintain such records as the Attorney General may prescribe. The Attorney General requires any licensed dealer to retain those. And that form, in turn, includes the actual buyer question that Abransky answered falsely. Therefore, falsely answering a question on 4473 violates 924A1A. So, this stands for the proposition, and it's settled law at this point, whether you agree with it or not, that one person cannot buy a gun on behalf of another person, even if that person is not a prohibited person and can buy it on their own. There's nothing in here that says that there's a requirement that money change hands. It simply requires the actual person who's going to buy the gun go in and buy the gun. So you can't just ask your nephew to say, hey, buy a gun. Let's say, again, you live in Miami and there's a gun shop in Tampa, and that's the only shop in town that has the gun that you want. You can't call your buddy who lives in Tampa and say, hey, go buy this gun for me, and then next time we meet up, you can give it to me. That's a straw purchase. You can't do that. You've lied on the form, okay? The only exception that exists under any sort of law is actual gift giving, meaning if I want to buy my wife, let's say, a firearm for her birthday or for Christmas, I can go into a store and I can mark, yes, I'm the actual buyer, because I am the actual buyer. I am the one who is buying the firearm for myself, and then I am going to give it to her for Christmas or her birthday or whatever. So you're not lying in that case, because all gifts start with the person buying it and then giving it to somebody else. That's not a straw purchase because it's a gift. So if you want to buy a family member or a friend or something a gift for Christmas or holidays or whatever, you're perfectly permitted to do that as long as it is actually going to be a gift. But anything other than that, in my opinion, based on the statute and the case law, is going to be considered a straw purchase. So when you hear people out there say, oh, it's not a big deal as long as the other person isn't a prohibited person, you can do it, that's not true. If anybody says, well, it requires money to exchange hands, that's not true. All it requires is you to lie on the form. That, again, that applies to if you lie about marijuana, if you lie about being a felon, if you lie about what your address is. Those forms have to be accurate, and if you lie on them at all, you're going to get hit with this charge. So what I recommend, and there's a lot of dealers who actually get even sketchy about gifts. I think those are legal, but a lot of them get sketchy about gifts too. So what I always recommend is that, look, if you're going to buy somebody a gift, just get them a gift card, okay? Every gun shop on the planet is going to have a gift card. So if you want your wife to have a firearm for Christmas, go in there and buy her a gift card and print a picture of the firearm off the website and put it in a box so she opens it for that, or bring her with you or whatever, and then she can fill out the form herself, and she buys it herself. If you're married, it comes out of the same account. If you want it to truly be a gift, you can do that. You can buy it for a box and send it out. I just know that there are some dealers who are going to be sketchy about that. There are some dealers that if there's any hint at all that it's going to somebody else, they won't sell it to you. If two people walk in together and they're talking to each other, and like guy A is holding it and is like, hey man, this is a nice gun, I'd love to have it, and then guy B goes over and starts filling out the paperwork, a lot of them will say no, they're not going to do that because it looks a little sketchy, and they're not going to risk their FFL license for that. So just be aware of that. And I know this is a little bit of a long video, but it's something that I needed to kind of clarify for people because it is a little bit confusing. So just be careful out there. Do not under any circumstances lie on those forms, but stop using the phrase straw purchase. Personally, I think it should be banned from the gun community because it causes all kinds of confusion, and it's something from a defense attorney, an attorney standpoint, doesn't legally exist. So thanks for watching the video. Again, like, share, and subscribe. Comment down below. I'll be happy to talk to you and let you know what's going on. I'll put the links to these cases and statutes and jury instructions and stuff in the description below. And as always, keep yourself safe, stay healthy, stay vigilant, and as always, carry on.